All right, we have matters set at both 9 o'clock and 9:30 this morning through some scheduling quirk, but why don't we call the 9 o'clock matters and see how things go.
The matter is Allied Healthcare Products, Inc.
Appearances, please.
Morning, Your Honor. Ryan Hardy for the debtor, and with me is Zach Farley.
Morning.
Morning. Brian Hockett on behalf of Sterling, the DIP lender.
Morning.
Morning, Your Honor. Carol Richick on behalf of the U.S. Trustee.
Morning. Anyone else in the courtroom? And on WebEx?
Morning, Your Honor. Scott Davidson from King & Spalding for Allied Medical, the asset purchaser. I believe Erin Edelman is on her way in because she will be asset purchaser but she'll be here soon.
Yes, we heard from Ms. Edelman, and we will not start the sale motion without her. But welcome again, Mr. Davidson.
Thank you very much.
All right, why don't we begin per the calendar with the keep motion.
Thank you, Your Honor. For the record, Ryan Hardy. We're here on, as you noted, the keep motion ECF 11. The motion is supported by the declarations of Akasha Min, who is in the courtroom today. Those appear at ECF 19 and 141. Would they be admitted, please?
I believe 19 is already in the record, probably from prior hearings. Would anyone wish to cross-examine Mr. Amin about his declaration document 141 filed on June 22nd? Hearing none, that declaration will be admitted.
Thank you, Your Honor. You've seen the motion. It seeks approval of an incentive bonus pool for certain key employees that comprises 2% of the net sale proceeds of substantially all the debtor's assets. The reason for the keep, of course, is to incentivize these 5 participating employees to do additional post-petition duties above and beyond their ordinary duties to make sure that this sale goes through. As Your Honor is aware, and as you're about to hear at 9:30, we are expecting sales. We're hoping that these sales are going to go through, anticipating over $8 million in proceeds. Conversely, we're anticipating currently the value of the keep pool to be a little bit less than $180,000. So we certainly consider it to be accretive to the estate and reasonable in relation to the anticipated proceeds. We did receive some comments, of course, and they were justified, and that was the reasoning behind submitting the supplemental declaration, simply to explain chiefly what precisely these additional duties are, and to make clear that, in fact, yes, these 5 employees do actually need to perform these additional duties to be entitled to the payout. This is not a layup. And those additional duties are described more fully at paragraph 14 of the supplemental declaration. If Your Honor has any questions about those duties, I'll be happy to answer them. But in the end, what it boils down to is, this sale is beneficial to the estate. We need these people to get this sale done quickly, efficiently, effectively. And in our estimation, without the keep, that's not going to happen. So in the exercise of business judgment, we consider it appropriate. We'd ask that it be approved.
All right. Anyone else wish to be heard on the keep motion? All right. There are no filed objections. Not aware of any informal objections. I assume you are not either, Mr. Hardy, other than the ones that were addressed already?
That's correct.
I've reviewed the motion and the declaration. The declaration is extremely thorough. I'm having trouble remembering such a robust defense of a motion like this. It was very helpful to lay out all that detail for me. The motion appears to be reasonable in an exercise of the debtor's business judgment, and I will grant it.
Thank you, Your Honor. Your Honor, I believe the next on the docket is the application to employ Stretto as a noticing agent. It's ECF 88. It is supported by the embedded Baton's declaration and also the engagement letter, which also is attached to it. To the extent necessary, I move that those be admitted, please.
Sure. Any objection to the admission of the Baton's declaration, document 88-1? Without objection. Admitted.
Your Honor, this is a pretty straightforward administrative motion. More than anything, we'd ask that it be approved. We think it's appropriate in the circumstances of this case. There is a fairly large group of notice parties here, and it is an efficient and quick way. And frankly, just when I get calls from creditors, honestly, it's very, very helpful for me to be able to refer people to the case website because that, of course, is, they can find all the information that they need there.
Certainly.
The clerk has approved, has reviewed, I understand, and approved the proposed order, and it does not include any indemnification language. So we ask that that order please be entered.
Anyone wish to be heard on the Stretto motion, application? All right. There are no objections to the application. I also noted that there was no indemnification language in the order. I will check with the clerk's office, as you know, it is typical to include indemnification language, and I was inclined to drop in the language from the Forvis order, which I believe is the same as Morris Anderson and the investment bankers. But I will check on that. The clerk of court is out of town this week. I will figure that out, and so that may get added in here along the same terms as the other non-lawyer professionals. There are also a couple of provisions that required certificate of service to be filed within 7 days or 7 business days. We're going to tighten those down to 2 business days, more consistent with our regular practice here. As you know, it's helpful for court users and the public to understand what's been served and when and on whom. And I also think the most fast-paced aspects of this case are about to be behind us, and so I don't think it'd be too much of a burden to Stretto to get that done in a couple days.
I'm confident that they can do it.
It seems that they're very good at that, so I think they can take care of that. So with that potential qualification on the indemnification language, I'll grant the application.
Thank you, Your Honor. The application to employ Greensfelder as special counsel, ECF 117 is next. It is supported by the Chode Declaration, which we would move to be admitted. I suppose it's 117-1.
Any objection to the admission of document 117-1, the Chode Declaration? All right, it's admitted.
Thank you, Your Honor. Greensfelder historically has represented the debtor in various corporate and securities matters. We anticipate that simply for continuity's sake, it's going to be more efficient for Greensfelder to continue performing those services than it would be for Spencer Fain to get up to speed and bring more lawyers into the fold than are necessary. That's the motivating factor, of course, and I'll say this now, and it's going to apply with equal force to the McMahon-Berger application later. Of course, we're going to be talking with them and making sure that we're not duplicating work. That's
sure.
Not something that we have any interest in. And honestly, if at any point I'm doing securities work in this case, something's gone terribly wrong. So I think it's best if Greensfelder.
Richek will take a close look at your fee application to see if there's any securities work being done by you and your colleagues.
So,
actually, real clear for the record, we do, Spencer Fain has completed some of the securities filings. Greensfelder's not doing the securities filings.
But the two of you, presumably, are not doing securities filings.
That is correct.
We'll be on the lookout for that in particular. All right.
Correct.
All right. Very good.
So with that, Your Honor, we'd ask that the Greensfelder application please be approved.
All right. I reviewed the application and the declaration. I'm not aware of any objection. I will grant the application.
Your Honor, next up is the application to employ Forvis ECF 118. It is supported by the embedded Amin Declaration as well as ECF 134, the amended Hammernick Declaration. I move that those please be received.
Any objection to the receipt of those two declarations? Desire to cross-examine? All right. They're admitted.
Your Honor, as explained in the application, Forvis has and continues to provide sales support. Obviously, this sale is quite essential to the success of this case and, of course, dealing with the related tax consequences as well. Forvis, according to the declaration, is well equipped. I can tell you from experience that I find them to be quite competent and good, and we would ask that Forvis's application please be approved.
All right. Anyone wish to be heard? Very good. I've reviewed the application supporting documents, and I noted that the indemnification language is included in the proposed order submitted by your colleagues, you or your colleagues, and on that basis, I will grant the application.
Thank you, Your Honor. Then finally is the application to employ the law firm of McMahon-Berger, ECF 126, which is supported by the embedded Amin Declaration, and ECF 133, the amended declaration, and 133, the amended Fritz declaration. Move that those please be received.
Any objection to the consideration of the two declarations cited by Mr. Hardy? Or desire to cross-examine? Very good. They're admitted.
Your Honor, as with Greensfelder, the purpose behind this application is to ensure that law firms who have historically represented the debtor can continue in their specialized representations. In this instance, it's labor and employment. There is obviously some union aspects to this case that need to be worked through, as well as ordinary course L&E issues that are going to come up from time to time. There's, as you've seen, a declaration on file. McMahon-Berger, of course, has a sterling reputation in this field. And again, we will be making sure that the Spencer Fane team is not duplicating work with McMahon-Berger. We ask that that application be approved, please.
Anyone wish to be heard on the McMahon-Berger application? All right, hearing none. I have reviewed the application supporting materials. I'm not aware of any objection. Mr. Hardy, I draw your attention to paragraph 15 of the Fritz declaration. It has some language that we saw in one of the earlier declarations. Might have been your firm's, might have been somebody else. The last sentence reads that the debtor will not be liable for fees or costs incurred by the firm in its representation of the debtor, which I think is probably not what's intended. So, I'm sorry, I'll wait for you to get there.
That's okay. The debtor nor its members are willing. Yes, I'm quite sure that's not what it's intended.
So I will leave it up to you to discuss that with McMahon-Berger and let us know whether you like the order entered now or whether they would like to correct that first and then have the order entered.
I will inquire with them.
Okay, very good. Other than that potential amendment, the McMahon-Berger application is granted.
All right. Thank you, Your Honor. I'm going to make a quick note of that. And that concludes, I believe, the 9 o'clock docket. I would be happy to offer you an overview of where we are in the case, but frankly, I think the 9:30 docket kind of explains where we are in the case. But if there's any questions you have, if I can clear anything up for you, I'm happy to do it.
Thank you. I don't think so. I think we might as well wait until 9:30 just in case someone was hoping to show up and be heard on those sale motions. I don't know how likely that is, but since they were set for 9:30, we probably should take a short recess. First, did anyone else have anything that they believe should have been heard at 9 o'clock? All right, didn't think so. We'll be in recess until 9:30. Thank you very much. Please be seated. All right, now to our 9:30 matters. Still in the Allied case. Anyone else wish to enter an appearance who didn't enter at 9 o'clock?
Good morning, Your Honor. Erin Edelman of Armstrong Teasdale on behalf of Allied Medical, LLC.
Good morning.
And to the extent my co-counsel has not entered his appearance, Scott Davidson of King & Spalding.
Thank you.
Your Honor, Brian Flame on behalf of Albany Engineering.
Good morning. Marty, I assume we should take both sale motions together, at least in some respects?
Yes, good morning, Your Honor. Zach Farley for the debtor. I think that makes sense. There will be, I think, probably just one or two aspects where I'll highlight for Your Honor where they might differ.
Certainly.
So, Your Honor, it's great to be back in front of you as hopefully coming to the conclusion of something we started on May 8th, which was the petition date. We filed a sale motion that had it requested relief with respect to establishing sale procedures, and the second part of that was getting approval for the result of those sale procedures. We got approval for the sale procedures, went through that process. Now we have the results for you. And, Your Honor, as I stand here today, I'm very gratified by the result. When I look back a year ago, the debtor here was facing a very tough situation, and even 8 months ago when I got involved, it was facing a very tough situation. It was facing a liquidation. It was facing the loss of employees' jobs and livelihoods. It was facing an issue of how are we going to complete the environmental remediation obligations in New York? How are we going to deal with the landlord? how are we going to deal with a lot of these issues? And those issues and problems didn't have great solutions. Today, we stand here believing that we have solutions for these problems that are infinitely better than where we were 8 months ago. And Your Honor, the change in the circumstance, I believe, is really a function of the hard work of the professionals involved in this case, principally the investment banker, Ravinia Capital, and the financial advisor, Morris Anderson. The investment banker went out, scoured the market, found the stalking horse purchaser, and spearheaded a lengthy, hard-fought negotiation on the asset purchase agreements. And Morris Anderson, in that time, in the last year, has kept the debtor's head above water, has preserved value, and in fact, I believe, in some respects, probably has increased value. So, Your Honor, again, we're gratified with where we are, and you know, we'll walk through this, of course, but we believe this is a happy day. So first and foremost, looking at the certificates of service on this, we do believe that we've provided the proper notice on the motion, the procedures, the hearing. Those are at dockets 37, 38, 123, 124, 129, 147, and 148. Those last two, Your Honor, my understanding is they were forwarding instructions, and so there was a supplemental certificate of service filed with 147 and 148. Your Honor, now this motion does have two components with respect to the sale. Of course, approving the sale pursuant to 363, free and clear of all liens, but then also the assumption and assignment of certain contracts. With respect to the assumption and assignment, we asked for procedures from Your Honor to streamline that process. We sent out notices on the proposed assumption and assignment with cure amounts, and the certificate of service on that is at docket 124. Those notices are at docket 121 and 122. Your Honor, I'll circle back to this in a little bit, but ultimately the debtor did not receive any qualified bids, as that term is defined in the sale procedures. We think, of course, that's a function of we did such a great job on the front end and got a really great deal that the market had already spoken, but again, we'll come back to that. And so as a result, we did end up canceling the auctions. There was no need to have the auctions at that point. We didn't have qualified bids that would top the stalking horse purchaser. So, Your Honor, in sum, we believe we provided all of the adequate and required disclosures and notices with respect to the sale process, the agreements, the transactions contemplated by the agreements, and this hearing. Your Honor, we filed declarations in support of the sale at dockets 150 and 151. Those declarations are from Mr. Amin, from the Morris Anderson, who is the financial advisor, and he's also the president of the debtor currently. We also filed a declaration by Mr. Tom Goldblatt of Ravinia Capital, the investment banker. At this time, I'd move to admit those.
All right, let me take them one at a time. Number 150, the Goldblatt Declaration. Any objection to consideration of the Goldblatt Declaration? Desire to cross-examine Mr. Goldblatt? All right, 150 is admitted. And then 151, the declaration of Mr. Amin. Any objection to consideration of that declaration? Desire to cross-examine? 151 is admitted.
And Your Honor, I do just, for the record, want to state that Mr. Goldblatt did provide a declaration in support of the sales initially, attached as Exhibit 1 to the sale motions filed on May 8th. I believe that has already been admitted into evidence, but at this time would...
I believe it's already in the record as well.
Very good.
Anyone wish to be heard on that? Good, okay.
So, Your Honor, for a streamlined process, I proposed a proffer the witness testimony today. I assume that's okay.
In addition to the declarations?
Well, I'll just kind of run through it quickly.
Oh, just summarize it. Sure,
Yeah,
sure, of course.
So, Your Honor, the sale and marketing efforts, both pre-petition and post-petition, have been summarized in Mr. Goldblatt's declarations. But at a high level, you can see that there has been a significant amount of targeted outreach to players in this space. There have been a lot of conversations with particular prospects. We had 52 NDAs signed to get access to the data room, a data room maintained by the investment banker that contained really a voluminous amount of documents and really all of the information that we believe folks needed to kick the tires and figure out whether they wanted to participate in this or not. We had 9 potential bidders do site visits, And again, there's a lot of marketing materials. All of this is summarized in the Goldblatt declarations, but we believe there has been a really robust sale and marketing effort, both pre-petition and post-petition. Ultimately, Your Honor, we think this was a really fair process to all parties involved. We think that there was an opportunity for folks to come in and see if they wanted to participate. They could make an informed judgment about whether they wanted to participate, and they had a full opportunity to do so. And they chose not to do so, which again we think is a function of the fact that we got such a great deal pre-petition. The debtor reviewed the information and bids that were received. By the bid deadline, the debtor did not receive any qualified bids. The stalking horse was automatically deemed a successful or a qualified bid pursuant to the sale procedures. It, therefore, being the only qualified bid, was the successful bid. All other things being equal, Your Honor, we think that the stalking horse has submitted the highest and best offer. It has monetary and non-monetary components that are really important here. Number one, they're writing the biggest check. That's very important. Number two, there are non-monetary considerations, including folks are going to keep their jobs. There's going to be a going concern sale, preserving that value, getting a significant return greater than what we would see in a liquidation. And also really important here is preserving the fulfillment of the ongoing environmental remediation obligations in New York, which I anticipate the members of that community will be very pleased with. And so, Your Honor, together, we really believe this is the best deal that could be had. Additional time to market these assets is something that we don't believe is going to generate a higher or better offer, and in fact could very much risk the offer that we have now and lead to further deterioration of the debtor's operations. The employees have been living under this uncertain situation for about a year now, and understandably, I think, are pretty anxious to have some finality and to have some security in knowing that their employer is going to be there the next day. And so, of course, that goes to maintaining the value of the company. We believe that this sale is something that needs to happen very quickly and without delay. We have contemplated a pretty short turnaround in terms of a close after the sale order. We look forward to that date. A couple things I want to highlight here, Your Honor, is, again, we think this has been a very fair process, and if called to testify, Mr. Amin and Mr. Goldblatt would testify that, to the best of their knowledge, everyone has played by the rules, everyone has acted in good faith. There was very robust negotiating with the stalking horse. The stalking horse is not an insider or affiliate in any way of the debtor. This is a pure asset sale. It's not going to be a continuation of the debtor. And so, Your Honor, for all those reasons, we think that we have demonstrated a legal predicate under 363 for this sale, and for this sale to be a sale free and clear of liens. Without a sale free and clear, we don't believe that the stalking horse would be at the table at all. If they were, we'd be looking at a much lower recovery for folks. And under 363F, we believe we've satisfied the requirements for a sale free and clear. The principal secured lender has consented to the sale. There have been no objections to the sale, except for one, from Albany Electric Company, and we've been able to work that out. That's worked out in the New York sale order. High level, Your Honor, there needed to be some clarification about preserving covenants and easements with respect to the New York property that are in favor of Albany Electric Company and the town. Was never our intent to disturb those, and so we've included language to preserve that, and I believe
I saw that in the order. When you mentioned earlier how much the local folks would appreciate the environmental cleanup, it occurred to me that if you took away their park, they might not appreciate the environmental cleanup quite as much, but it sounds like that's not going to be a problem.
That's not going to be a problem, Your Honor. So there are no objections to the sale. This is unopposed. With respect to 365, assumption and assignment of the proposed contract or proposed purchase contracts, again, we provided notice pursuant to the procedures. We believe we've provided adequate assurance of future performance. We have not received any formal or informal objections to those proposed assumptions and assignments or cure amounts. And for all these reasons, Your Honor, we believe we've demonstrated sufficient business judgment and justification for approving these sales expeditiously and pursuant to the terms of these agreements. And because of the need to consummate these sales quickly, we do ask for the waiver of the 14-day stay rule and hope to have an order just as soon as possible so we can move to sale and move on to the other parts of this case. Your Honor, I did want to highlight one change or proposed change. This is with respect to both of the orders. It's at paragraph 47. This deals with a transition matter with the stocking horse. The stocking horse has requested additional time in which to have the opportunity to ask the debtor to assume and assign executory contracts, and the deadline is August 10th, in which the debtor will not reject before that date. We are going to change that to September 15th, that the debtor will not reject before that date.
All right. When I ask others if they have anything to say, I would encourage them to comment on that among any other issues they may have. But thank you for pointing that out. In reviewing the proposed orders, there was one finding that I couldn't tie down to a declaration. I may have missed it, but and I don't think it's likely to be very difficult for you to proffer for me. But that is the lack of an ombudsman, and in particular, the lack of a policy about personally identifiable information. It seems unlikely that a company with this business model would have consumers' personally identifiable information, but perhaps you could give me a proffer that would support that finding for both orders.
Your Honor, may I confer with my client?
Certainly, of course.
Thank you, Your Honor. If called, Mr. Amin would testify that the business model of the debtor is to sell directly to businesses, and it distributes these products. It doesn't sell directly to consumers, number one. And number two, it does not retain or collect personally identifiable information of individuals.
Okay. Mr. Amin, would that be your testimony? Thank you. Anyone wish to inquire? Didn't think so. All right, thank you. It's very helpful.
Thanks, Your Honor.
Anyone wish to be heard on either of the sale motions?
Good morning again, Your Honor. Erin Edelman on behalf of Allied Medical, LLC. Mr. Farley's statements on the record this morning were correct. First, in regard to the moving that date out to September 15th, we've conferred with the debtor, and Mr. Farley's statements on the record were correct in that regard. Just in general, Allied Medical is obviously very supportive of the entry of both of the sale orders this morning, which Allied Medical has had time to extensively review and approve this morning. And we would just like to thank the debtors team and Your Honor and the court staff for such an organized and expeditious sale process, which yielded a great result for the debtors and our client, Allied Medical.
Very good. Thank you. Anyone else? All right. Taking both sale motions together, having heard the evidence and arguments of counsel, I will approve both sales. Evidence before me shows that the notice of the proposed sale was appropriate and sufficient under the circumstances, and that the marketing and potential auction processes were conducted in accordance with the bankruptcy code, the rules, and the bidding procedures orders. I find that the debtor has shown a good business reason to sell its assets outside of the planned confirmation process, in particular the extensive pre-petition marketing efforts, the timelines posed by the lender, and the involvement of competent professionals. The sale free and clear of liens and other interests in the assets is appropriate under Section 363F. I find that parties with liens or other interests in the assets sold be adequately protected by the attachment of their liens and interests to the sale proceeds. In addition, I find that the purchasers demonstrated adequate assurance of future performance of the executory contracts and unexpired leases to be signed to it, and I believe the purchasers proceeding in good faith and therefore should be entitled to the protection of Section 363M of the Bankruptcy Code. Under the circumstances, I don't believe it's appropriate for the sale order to be stayed for 14 days, and therefore I'll order that the Rule 6004H and 6006D stays will not apply to the sale order. Are there any further findings that any party believes are necessary other than the ones the more extensive ones in the proposed orders, of course.
Not from the debtor, Your Honor.
All right. So therefore, both motions will be granted. Anything further on Allied today?
Your Honor, I would just echo Ms. Edelman's statements and thanking Your Honor and his staff in helping us move this process along, and we just appreciate keeping this process so organized.
Sure. That's what we're here for. And thank you to all parties for your hard work in pulling this together. Congratulations to the debtor and its constituents. Congratulations to the purchaser. Congratulations to the DIP lender, which I imagine will be paid off shortly. And we'll look forward to seeing you all in connection with the next phase of this case, whatever that may be. We will be adjourned.